All rise. The Court of Appeals Division 1 is now in session.
Thank you. Please be seated. We're here for oral argument in our case number CV23 0236, Tiger versus Pennell, if I'm saying that correctly. We are recording and live streaming the argument, so please identify yourselves at the beginning of your argument as well as your client, please. And each will have 15 minutes. Apologize for that, but we're under some tight time constraints this morning. But you're not obligated to use all that time, but appellant's counsel, you're responsible to watch the clock and reserve as much time as you wish for rebuttal. Please keep in mind we've read the briefs, we've studied the record, and we've conferenced the case. Counsel for appellant, you may proceed.
Morning. May it please the court, Keith Berkshire for the attorney for the appellant, Michael Pennell. This case really comes down to one of due process. And about 9 years ago, I argued the Volk case, which has become one of the main cases in Arizona on what due process meant. And Volk was argued in 2014 prior to the change to RCAP 11, which allows you guys to look at FTRs, videos, and so forth. And interestingly, in that case, because the transcript, it was so hard to tell what the transcript said about what happened at the hearing, Judge Swan actually ordered the CD and mentioned it during the oral argument that he had watched the hearing 3 times and he couldn't tell what had happened in the case or even what my client did for a living at a child support hearing. And frankly, if you watch this hearing, it's as bad as that, if not worse in some ways. So of how this number was arbitrarily picked from the sky, not upon a request from mother, by the court. And, obviously I could ask for you to, look at the hearing under RCAP 11, but it really is that bad. I mean, I've never gone after judges in any of my briefs other than saying they misapplied the law. But this was an offensive hearing to watch of how this number was suggested by the court to mother. And despite the statement, and I got to give mother's counsel at the trial court credit that Ms. Scott said flat out, we did not plead a deviation here. And I would have to amend to ask for that.
Well, counsel, is that accurate, though? I mean, have we ever required a party to plead deviation, or can that even end up in the final pretrial? Those things come up fairly late in child support. Not talking about spousal maintenance, but child support at least.
Well, here in a default hearing, how would they know? I mean, this is the intricacy.
Different, but I'm just saying in general.
Well, I do agree. I think that it is, deviations come up a lot. And there is actually quite a bit about disputes when somebody tries to do into the pretrial statement that, hey, you never requested a deviation, nothing, even an RMC statement, things like that they never had noticed. So that issue does come up a lot about what is the meaning if I'm asking for child support under the guidelines. And I think that and on this issue, the notice issue, I think that's I think that's somewhat solved by the statute, because if you look at what the statute actually says on it, okay, 25320D, it says the Supreme Court shall establish guidelines. And then it talks about the Supreme Court shall base the guidelines and criteria for deviating from them. So if we're going off of a request of what the guidelines meant, then you look at the statute that says guidelines and then a deviation from the guidelines applies that it's not the guidelines. Now,
so are you asking us to hold that there shall be no child support deviation unless it's in the complaint or the answer?
I think at least
or I should petition a response.
I think that there, again, some of the amendments to some of the rules lately, like Rule 76.1 allows for a notice of claims and so forth. I think that solves the issue about having notice. But as far as a default goes, I think it has to be specifically pled. I think it would honestly help for the court to say that the deviations must be specifically pled. I do think that's something similar to, because it is so different than 99.9% of the cases that use an application of the straight guideline calculator. Because again, even in the guidelines themselves, step 11, if you look at essentially I think it's page 2 of the guidelines, it says deviation, the court orders this amount to be paid unless the court determines a deviation is appropriate based on a request from the party. Okay, where's the request? The guidelines themselves refer to guidelines and then deviations from the guidelines. The court must deviate in section 9 under A and B. It says the court must deviate if the guideline amount is inappropriate. So what is it? So here, a party has a right to rely upon the notice, the pleading, the complaint, and say, okay, let's say my client thinks that the 3145 that mother had in her form of order that she went to the hearing with was appropriate. He can run his guideline amount, say, max my income out to the sky and cap it out, and I know that the total risk I'm going to pay is $3,000. I don't need to show up. I know I'm the kid's father. I don't need to show up because that's the max. So that's the idea of a default, and it's the idea of the case law on defaults, that you have to at least have notice of what the repercussions are for not showing up. Under Mother's argument, essentially, she could have gone to this hearing, and we'll get into that there's no evidence here in a second, but she could have gone to this hearing and asked for $100,000 a month. That would have been supported, as well as the $10,000 that the court picked. And so here, the notice and a default, you have to have some knowledge of what you're applying. The term guidelines is the calculator. The guidelines themselves refer to guidelines.
Isn't that what due process is? Due process is when a statute or guidelines give you prospective notice of what will happen at the hearing, right? Isn't that your point?
It is. I mean, if it's the same as like the Klein case, that they didn't plead spousal or something of these issues where that comes up. So here, the guidelines is a unquestioned term, even within the statute themselves, but it is the calculator. It is the guideline amount. Now, is it potentially worded a little? Could they, call it two different things instead of using, the title? I'll admit the title of the document. I'll go sit on my desk. The title of the document is Arizona Child Support Guidelines. That document, the 100-page PDF put out by the Supreme Court, does have deviation language in it. I understand that. However, if you look at the wording of the statute, establish guidelines and deviation from them. So if I'm saying guidelines, you can't subsume the deviations from those into the same exact word.
Sorry to interrupt. I'd like to spend at least a couple minutes on service. I'd like to know your thoughts on that. Whether Mother showed that traditional service was impractical.
And Mother knew where my client lived in Missouri. Okay, that's not a dispute that she knew that was his last residential address. She did do a skip trace that showed this collar address that I guess maybe at this point it's undisputed my client has never lived there. So she did do a skip trace. There's technical issues within the service that we raise about did she send the adequate documents even under the alternative service. So we have the argument that she should have at least tried to personally serve him at the address that she knew he last was. We have the argument of, hey, he's a pro football player. It's not really hard to figure out where they are on Sundays. Those types of things. I mean, she got his income off the internet. She surely could find out where he's playing off the internet. Just go to send service to, process server to the home office of the team, his agent, one of the other multitude of things that are, able to be done in a 10-second Google search. But even that, just the address alone, that she never tried to do personal service at him. Beyond that, they never actually proved that they mailed the documents after the alternative service order came into effect. They never actually mailed all the documents to him. One of the requirements, and none of their affidavits of service, none of their application for default, anything, one of the required documents under the rule to be mailed is the order allowing alternative service. So if somebody gets it in the mail, they can see a court order that says, the court has granted my motion to do alternative service. None of the documents, none of the certificates of service, application for default, any of those mention the word order allowing for alternative service in them. So it's technically deficient on that end under the rule. We've got all the Supreme Court cases and a case from this court that says, service is not a technicality. You got to follow the orders and so forth. So,
what about the Missouri address?
It was posted on his door. I'll admit that they sent certified mail to his door. They at least mailed the application for default to his door that mentions in it that the court granted the order for alternative service. So, that stuff was mailed to him, and it was posted at his door.
And when you say at his door,
the Missouri.
The Missouri address.
Okay. Okay. That's the one that was his correct address. So it was posted there. They showed a photo of it, et cetera, of it being posted and so forth. But again,
after the motion for alternative service was granted.
Correct. It was mailed before and tried certified mail before, but then after the order allowing alternative service, they did comply and post it at the door. The Instagram, Facebook issue, it's how you read the order. Did it require both? Even their Dropbox, they admit that it didn't include the order for alternative service, nor did it include the summons. So if Facebook was allowed, it didn't include the summons, the one important document that says you'll be defaulted.
Can you require someone under our rules or constitutionally to have facility with Dropbox as a condition of being served? Does that make any sense?
I do have an issue with it. I have an issue with the case they cite about allowing Facebook. That's terrifying, especially as a pro athlete.
But there's a difference between DMing somebody and then saying, hey, I'm going to do something. You have to know how to use Dropbox to get it. Aren't those different, counsel?
I do. It's, you could have theoretically taken pictures of every document and sent them through a DM and Instagram.
I mean, are we going to start requiring lay people without sophisticated, complex counsel, such as we frequently see in this court, to be able to use Dropbox well? Is that going to become part of Rule 4.1 now?
I mean, I do have a big issue with that, and I do have an issue because, I mean, even some of the simpler ones that are free and so forth, but, most attorneys have their own weird share file thing that requires you an account and validate this and all that stuff. So I do have an issue with that. I mean, it kind of defeats it. I mean, again, a service always goes back to Mullane, the U.S. Supreme Court case in the 50s that says it has to be reasonably calculated to, believe they can open it. I mean, with Dropbox too, the head of Google, assumedly he knows what it is, or the head of Dropbox. I mean, that would be calculated because he has an account and so forth. But here, let's look at the Instagram thing. This guy's a pro athlete. I mean, there's no proof he ever, to do DMs, you have to actually accept the person. So, pro athlete, I mean, if I DM'd, any celebrity, they're not going to open it. They're not going to even accept it because they probably get 10,000 of those a day. So is that reasonably calculated? But even that, it fails within the rule itself because there's no acknowledgement that they included the order, which is key. And the purpose of that rule is to notify somebody. They get the mail and they say, oh, the court did allow this. Oh, it's not just junk mail. So, there's a purpose behind the rule, and there's no document that ever mentions in any mailing certificate anywhere that the order was sent.
So, counsel, you're asking us, the service issue comes down to a constitutional right and actual compliance with the rule. We have whether there was proper notice under the default constitutional due process. Now we have a fairly simple way to get at this, which is insufficiency of the evidence. As I understand it, and I'll ask counsel to comment on this, what the evidence was, mother, I apologize for that. Mother asked for guideline amount. After the judge said something, mother asked for $6,000. That was testimony. So at least there's testimony up to $6,000. After that, there is nothing to support the $10,000. Just a judge saying, I was thinking $10,000 and okay, that would be okay, but no even testimony. And even for the $6,000, arguably, there was no testimony to say it was in the child's best interest and why. So isn't it really the cleaner straight line is there's just not enough evidence under these facts, as you said when you watched the hearing, to say a $10,000 amount is appropriate?
I agree. I mean, I think that before you went back to the $6,000, I was going to say there wasn't evidence, so you beat me to it on the $6,000 amount. We start from the guidelines. You don't need evidence on the guidelines other than, an argument about what their incomes are. So, I've been to a lot of these default hearings. It's what are their incomes, where'd you get it? There was enough of mother testifying, I got it off the internet. Now, is that his income after agents and everything? Probably not. But there's enough evidence on those, on what the incomes were, medical, with the worksheet and so forth, to support the 3145. My client's position is send this back to the Superior Court with an order to enter the 3145 retroactive to the date of birth. And we're not never contested the $12,000 in medical. That's our position, is send it back because there's no evidence to go above that. This is the real argument here is, the reading of the guidelines as to what is sufficient evidence. This is the Pearson case, this is the Kell's case, and so forth about what you actually need. Do you need to go through all the factors? Their argument is that it's essentially discretionary to cover these factors. But if you look in the guidelines section 9, it specifically references, this is one of the, I think this actually now in the spousal guidelines too, they make a reference that's somewhat odd, which the guidelines actually say you have to, under section 9, subpart A, it says you have to look at all factors under 25.320 and case law before you come up with a deviation. So it's actually a weird reference to that.
If 3145 is like the undisputed amount, as we would say in a civil setting, has your client tried to proffer the 3145 retroactive?
Well, the garnishments took actually all $190,000
Okay.
and his monthly amount, so he's about $200,000 overage.
Okay. So that it was unnecessary for him to do so because of the garnishment.
Yeah, well, the order of assignment went into effect immediately,
Okay.
and the state, because of all the remedies that the beautiful remedies the state has, took his bonus, which I don't know the exact amount now. She's been massively overpaid above the 3145 at this point, is my understanding. So
you're just asking it to be drawn back to that level.
I'm just asking that the order specifically, we don't need another hearing, we don't need anything, just a court order that the 3145 goes back to the date of birth, is probably the right remedy. I mean, service is jurisdictional, so can you get there? But again, my client's position is the 3145 is an adequate amount. But that's the real issue under the deviation thing is the deviation issue is there has to be some sort of evidence here. You don't know that, okay, he makes $1 million a year. Warren Buffett lives in a $700,000 house. Okay, that doesn't mean anything, that what Warren Buffett makes versus the lifestyle. You look at the Nash case. Nash is, when this court came out with Nash, it talks about equalizing lifestyles. There's not any evidence of what this kid's lifestyle would be with my client that you're trying to equalize. There actually is one, and that's he lives in an apartment. So it's not, if they had served him on his, in his mansion in Malibu, then that could be something. He doesn't have one. But I'm saying if that was the case, but the one piece of evidence, the only piece of evidence is that you served him in an apartment. There's no discussion of lifestyle or anything else that you could get to this concept under Nash of equalizing the lifestyles. I'll save my 20 seconds.
Okay. Thank you. Counsel.
Good morning. May it please the court. My name is Chris Torrenzano, appearing on behalf of Appellee, Mr. Tiger, who is the petitioner at the lower court level. Now, considering the time allotted and the bench's consideration in terms of what issues should be prioritized, I'm happy to diverge, but I'm hoping to address the three issues that were just discussed, two pertaining to notice and one pertaining to what the trial court is required to do when entering a deviated amount pursuant to ARS 25320 and the guidelines. Now, regarding the first argument that was touched upon, which is with regard to the pleading requirement, whether or not a trial court is allowed to deviate in a default proceeding, regardless of whether or not a deviation is specifically pled in the petition, I think the court noted there's no such requirement. There's nothing that exists. ARFLP 24A requires a general statement regarding the relief that is sought. In Cochran, the Supreme Court notes that the petition does not need to be technically sufficient, but needs to make a general statement about what is being requested. Arizona is a notice pleading standard. And it is our position that Mr. Pennell was on notice that child support would be at issue, which would permit the trial court to deviate. Now,
Is it different for default? Because can we say, look, as the case develops, perhaps, that it can, as long as it's in the final pretrial, arguably under our rules, that's enough. But default seems a little different.
default does seem a little different. However, based on how the rules are structured, when ARFLP 44 was initially put into place, it essentially mirrored the language in the Rules of Civil Procedure, which I think at the time was Rule 54 regarding defaults. And it included the notion that a default judgment cannot exceed the relief requested or be different in kind than that which was included in the initial petition. The Rules of Family Law Procedure then evolved to adapt to the family court system, and 44 was divided into 44.1 and 44.2. And in 44.1, it addresses defaults with respect to those that judgments that are entered without a hearing, and 44.2 addresses defaults that are entered after a hearing. The language about a judgment being entered that is different in kind or exceeding the relief is included specifically within 44.1, meaning without a hearing, something different cannot be entered. However, the court is permitted to hold a hearing and conduct a hearing necessary to determine the factual issues, determine the appropriate relief to be granted, and enter an appropriate judgment, which leads me to believe that even in a default proceeding, the court maintains its discretion to determine that a strict application of the guidelines would be inappropriate or unjust, and that a deviation would be appropriate in these circumstances. Additionally, in the default rules, there's specific language regarding spousal maintenance, there's specific language regarding past child support judgments, specific language that must be included in order to secure those types of judgments. No such language exists for deviations, which leads me to believe that no, the court is not strict of its discretion to determine that the guidelines are inappropriate in a particular situation and to enter a deviated amount.
So here the court could have gone to 20, 30, 40, 50,000 without a problem?
No. So then this is why, right, we're dealing with kind of two issues. One is whether or not the court on its face, kind of in a binary sense, is permitted to deviate in a default proceeding. And then the second level of analysis or second degree of consideration is then what number are we looking at? Which I believe is...
So you'd agree it has to be supported by the record, the number?
Yes. Supported by the record and supported by the findings that the court makes. So I would concede to that point. And in this particular
Well,
situation...
the findings have to be supported by the record, too.
Correct.
Okay.
Correct. In this particular situation, which I feel we may be transitioning into the second issue, which is regarding whether or not the trial court complied with ARS 25320 and the guidelines when entering the deviated amount. Now, in this particular situation, the trial court considered the evidence that was before it, which at that time was that mother was a kindergarten teacher, earning about $25 an hour, and father earned 1.12 annually based upon the publicly available contract, 1.12 million, excuse me. The court then figured, considering the relative incomes of the parties, that a strict application of the guidelines would be inappropriate. Specifically, the court references standard of living. It takes into consideration the fact that a child born in a household that has a parent who's earning over $1 million a year would likely be subjected to a standard of living that is much higher than what the guidelines are trying to support.
Well, based on what evidence? Beyond speculation.
Beyond speculation, and it's really just it's predominantly an extrapolation from the guidelines themselves in this particular situation. Meaning,
I don't understand what that means.
fair, and let me clarify. The court essentially said, based upon its analysis and the findings, that if 3145 is the appropriate amount considering a strict application of the guidelines, which the combined monthly income, where it maxes out on the chart, is $30,000, and father's earning $93,000 a month, then the court essentially extrapolated out to say then a 3x multiple would make sense in this situation.
Where in the guidelines does it say as long as there's a significant income, you don't need anything more? Because that's all we have in the record.
Correct.
And I don't see in the guidelines where it says, as long as you got a big income difference, we're done. That is not one of the you get a deviation boxes. You have to consider all the factors.
So it's our understanding that one of the things that could trigger a deviation is that if there's a significant disparity in income, is that it may be appropriate. And then it's a question of...
So we're at the could be appropriate.
Correct.
Now I'm at the is it. Could be is different.
Right. And the court, in the court's analysis, the court noted in its findings that the standard of living it expected the parties, or at least the child, to experience if it lived in an intact household, which the court noted was one of the primary aims of the child support guidelines, is to try to recreate a scenario of what the child would experience in an intact household. It tried to then structure the financial situation to reflect that, and it led to the $10,000.
How do we know that $10,000 even approximates that, though? There's nothing.
That's a fair comment. And the challenge here is that without father participating, it's difficult to discern exactly what standard of living he was experiencing. And the question really then leads to this kind of level of inquiry of, to what extent can the court consider standard of living when the party who's experiencing that heightened level is unavailable or unwilling to participate to present what that standard of living would be.
Or when the party with the lower standard of living isn't arguing for that much. I mean, that complicates the analysis further.
I'm so sorry, I missed the
I'm
beginning.
saying, and the party with the lower standard of living is not advocating for this 10,000 number that was pulled out of the air, so that makes it harder too.
That is a fair comment, yes. It really is born from the discretion of the court based upon how the discussion unfolded. Was mother did not initially request a deviation, partially because of a mistaken belief that it had to be, or it may needed to have been pled in order for it to be in a conversation, and considering kind of the onerous extent to which you try to serve father. Oh, please.
That thing you said is important, counsel, so I apologize
Certainly.
for the interjection in
Yes.
this short time. But, I mean, the fundamentals of due process, I was taught in law school, is notice and an opportunity to be heard. So when mother's not seeking it, I mean, what notice does opposing party have in a default setting of coming in and being hit with that $10,000? I mean, how is that due process?
Due process in this particular situation kind of goes back to the fact that father was on notice that child support was going to be at issue before the court, and that the language
But the deviation would not, though, right? And you already said that, because it wasn't sought originally.
It wasn't sought originally, but that doesn't strip necessarily the court's ability to leverage its discretion or to exercise its discretion to determine that's appropriate.
Well, but a sua sponte determination that wasn't pled, I mean, to say that the court might be allowed to do it isn't the same as saying that that client had notice and an opportunity to be heard on the issue where there's no inkling that's going to happen in open court.
I suppose what we're alleging in this situation worth exploring is when a party pleads a general request for child support commensurate with the guidelines, is another party on notice that a deviation could occur. And what we're saying is that they are, is that it could occur such that they should respond and participate if they want to ensure, or at least be able to present evidence that's going to.
I've got a different constitutional question for you. It's of great concern to me.
Absolutely.
Because of the importance of rules in our court system. But how is it consistent with constitutional minima of notice to set up a regime under Rule 4.1, I think it is, that alternative service can be affected by requiring someone to be facile with and to utilize Dropbox? I'm stuck on that.
Certainly.
How can that be?
So what I want to do here is kind of extrapolate and then narrow back, or I'm going to avoid using that word. I'm going to expand and then kind of refocus. So Mullane is kind of the seminal case.
They didn't have Dropbox in 1956, but
that is correct. But Mullane is the kind of quintessential, or the seminal case in the Supreme Court, right, that states that when thinking about service and due process, you have to consider the particularities, I believe it's the practicalities and peculiarities of the particular case to determine whether or not the efforts were reasonably calculated to notify the other party. In this situation, Dropbox was just one of a number of ways in which mother was attempting to contact father.
Wasn't it needed to effectuate service through the DM device through Instagram? Isn't that the pathway that required eventually the use of Dropbox?
The use of Dropbox was used in that particular method, which Dropbox is essentially just a link that once clicked upon, it opens up the document. There'd be no difference.
Yeah, if you've got a computer to click upon it, we let people do things in paper in this building still. We let pro se people do that. So establishing that it's constitutionally minimally acceptable to require Dropbox service would be highly inconsistent with the paper practice that persists in this court to this day. That's a concern.
And I think it's a fair point if we were trying to say that should be able to be applied in any and every single matter. I think what's important in this particular case is that you have a professional football player who's been active on social media accounts who clearly has the capacity to use his technology to the extent that he can click a link, which is essentially what Dropbox is. You don't need to have your own account. It's quite literally just a storage device to put the documents in the cloud so that enough documents can be transmitted through a specific means. Because if you tried to send the documents solely through Instagram, I'm assuming it would be a mess. Personally, I don't know exactly what it would look like, but it's a much cleaner, more organized format to send a link that can be clicked upon, which is just one in a series.
And that's what the order said. The thing that you said would be a mess. It says Facebook/Instagram, ambiguous as to both or either, and you just said service on Instagram would be a mess.
If it was not leveraged using Dropbox.
Okay, which is not mentioned in the order and which not everybody uses.
This is true.
Okay.
Counsel, why even get to alternative service? I'm struggling with why alternative service was justified when there was no attempt to send a process server to his Colorado address.
Through Missouri.
Sorry, Missouri.
Appreciated that.
Thank you for correcting. Missouri.
The sequence of events was such that after the skip trace was run, the updated current address was the Colorado address, and the last known address was the Missouri address. And then mother sent out a flurry of attempts to try to contact father. She sent personal service to the updated current address, which was the Colorado one, which proved unsuccessful. And to your point, did not send personal service beyond posting the documents on the door.
But that was after posting the documents on the door.
Correct.
Was after the motion was granted.
Correct.
We talked about before efforts. Why was it impracticable to? How could the court reasonably make that finding if there had been no effort to send a process server to one of the two places that he lives?
Mm-hmm.
And the one that had been identified as the last known address, if you don't mind that friendly amendment.
Yeah.
No, fair. Honestly, at that point, I imagine I can't dive into the court's head to provide the exact explanation, if I'm being quite honest. But what I imagine is at that time, what the court, and I have to recall if the court was aware that father was evading service at that point. I don't know if that was in the record.
Did the court ever make a ruling that father evaded service?
No, mother was aware that when she reached out to father, he said she would not get a dime or DNA, and subsequently blocked her on all social media and communication accounts. So I imagine at that point the court found it sufficient that mother was attempting to contact father through the updated current address and was still sending communication to the last known address, and believed that subsequent efforts through alternative service, which in this case would be posting them on the door, would lead to him being notified. I think one of the peculiar elements of this particular situation, though, is that I don't know if father ever actually claims that he did not receive notice. from a service standpoint, I can't, from reviewing the briefs, I don't know if it's ever explicitly stated that he didn't actually receive the documents.
Is that a requirement under the, can you cite a case that says that a defendant has to say that I've never received notice?
Oh, no, I'm just saying if a due process error is reversible if there's prejudice, but I presume prejudice
I mean,
would
we're
exist.
just applying the rules as written, right? That's all we're trying to do here is apply the rules and then under Mullane and under the case law to see if adequate notice was provided.
And I suppose that's where we're coming from, is that considering kind of the myriad of efforts that Mother put forward between the personal service attempts at the updated current address, the certified mail, the 2 applications for default, posting documents on both doors, and sending an Instagram message, despite all of her personal communications being blocked, that she had put forth reasonable efforts to try to contact him, including contacting a process server in Atlanta to determine if she could serve him at his work.
Was she blocked from his Instagram?
Yes, yeah.
She was blocked from his Instagram?
That's what he says in his motion to set aside.
And
that
so what was the means by which it was transmitted by Instagram, hers or other?
the attorney's office had to send
The
it out.
attorneys. The attorney was not blocked.
No.
And how many DMs does he receive per day on Instagram? Do you know?
This I'm unfamiliar
Okay.
with.
Okay, Counselor,
I'm
time
at
is up,
time.
so thank you very much.
Thank you.
Thank you. You've got 21
In my
seconds.
21 seconds. I think, the part of the transcript that I think is just the egregious part of this is the part that Judge Jacobs was talking about, which is, the court starts talking about a deviation, and Ms. Tiger says, so I would say I want to double that or 6,000. The next sentence is, the court, I think that it should be 10,000. And the witness says, oh, 10, okay, 10,000. And the lawyer says, okay, that was in my head. And the court then says that was what the evidence supports. Later, in the same next page, when they're talking about the arrears, the court goes, well, at least I picked a round number.
Counselor, we thank you both for your arguments this morning. The court will take this matter under advisement, issue a decision in due course. The court is now adjourned. Thank you.